1776, after declaring independence from Britain, the United States of America had to figure out how they're going to govern themselves to be a successful country. The first written constitution was called the Articles of Confederation. Issued in 1777, this plan created a government that had no president, no executive branch, no court system, and no way to tax the people. Since they had no money and no method to obtain money, the federal government had no way to pay off debts from the Revolutionary War, except by increasing taxes from the states and selling land in the Northwest Territory. By 1787, the United States fell under an economic depression. Farmers in particular were very much affected by this and were in deep debt. As a result, Daniel Shays, a veteran of the Revolutionary War, led a group of rebels to try to take weapons and overthrow the government. Although Shays' rebellion was unsuccessful in overthrowing the government, it had significant impact because it forced the federal government to try to revise the Articles of Confederation to create a more powerful central government that would help the people. The result of the attempt to revise the Articles of Confederation was a whole new document called the United States Constitution. It was written in 1787, mainly by James Madison, who is often known as the father of the Constitution. The Constitution has 6 goals and is based on 7 major principles.
The introduction of the Constitution is called the Preamble. It lists the 6 goals for the United States government. An important man named Gouverneur Morris attended the Constitutional Convention as a delegate from Pennsylvania. He wrote the inspiring preamble and helped to write and edit much of the rest of the Constitution. He read the first line of the Constitution, "We the people of the United States."
The government's first goal was to make a more perfect nation under the Articles of Confederation. At the time, the states functioned like independent nations, often disagreeing on defense and finances. The framers believed the states needed to agree to operate as a single country and cooperate on major issues.
The government's second goal was to establish justice for the farmers and the people of America. Treating the people equally was a big deal for farmers. The Constitution provides a national system of courts to protect the people's rights and to hear cases involving violations of federal law and disputes among the states.
The government's third goal was to ensure domestic tranquility. The violent protests of Shays' Rebellion in 1786 shocked Americans and made them reconsider their government decision. The Constitution wants to keep the peace among the people.
The fourth goal is to provide for the common defense. Under the Articles of Confederation, the American government did not have a national militia. Instead, it had to rely on the state militia. The Constitution gives the federal government the power to maintain armed forces to protect the country and its citizens. The fifth goal is to promote general welfare. The Declaration of Independence states that the purpose of government is to promote life, liberty, and the pursuit of happiness for all the people in the nation. The Constitution includes promote the general welfare or well-being of the people by maintaining order, protecting individual liberties, regulating commerce and bankruptcies, promoting science and technology by granting patents. The sixth goal of government is to secure the blessings of liberty. The framers believed that the persevering liberty should be a major goal for generations to come. The Constitution guarantees that no American basic rights will be taken away now or for posterity. The sixth goal of the Constitution remains as important as today as they were when the Constitution was written.
The Constitution has 7 guiding principles, or rules. The first principle is popular sovereignty. The framers lived in a time when the kings believed that their power to rule comes from God, called divine right. The Constitution had a new idea that the government gets its authority to rule from the people. The preamble is the introduction to the Constitution. It was written by Gouverneur Morris. It begins with the words, "We the people," and it reflects the idea that it is the right of the people to govern themselves. The people are the source of the government's power. Republicanism is a form of government. Instead of having citizens directly participating in the government to help decide everything, citizens elect a representative to do the voting for them and carry out their wishes. Once elected, representatives must remain open to opinions of the people they represent. In our republic, the people of each state get to vote for their representatives. Each state gets 2 members in the Senate and a number of representatives in the House of Representatives based on the state's population. California has 53 representatives in the House of Representatives. California's representatives meet with the other representatives from other states to debate about their ideas. The representatives discuss a topic until they come to an agreement, which sometimes becomes a law.
In the 1700s, colonists lived under a king who abused his power and would tax the colonists when they had no representation in Parliament. The king misused his powers to take away the colonists' rights. The framers of the Constitution wanted to avoid tyranny in the new government. Tyranny is the abuse of power by the government, like they had with the king. They didn't want the country to be ruled under tyranny like they previously were. So the framers of the Constitution limited the powers of the new government by writing the Constitution. The Constitution says what the government can and cannot do. By writing the Constitution, the framers of the Constitution protected the people, and the government can only do what the Constitution says. This also created what is known as representative government. What is federalism? It is the division of powers between the national and state governments. There are certain things that the national and state governments can and can't do. Eventually, both must come to an agreement. For example, the national government has the power to regulate interstate trade, set standard weights and measures, admit new states, create federal courts, declare war, and establish post offices called enumerated powers. These are rules that must be followed by every state. States have their own powers. States can make corporation laws, regulate trade in their own borders, establish schools, establish local government, provide public safety, and make laws about marriage and divorce. Along with their own rules, the states must follow the rules of the Constitution and the national government. In some cases, concurrent powers are used by the national and state government to share their powers. For example, citizens get taxed on both states and national taxes. This forms the system of government still used to this day.
Based on the ideas of Baron de Montesquieu, the federal government is divided into three branches, each with their own articles. The first article of the three was labeled as legislative branch. This branch specializes in creation of laws. The second article is known as the executive branch. This branch is where a president is selected and where officials carry out the laws and oversee the government. This selected president represents the nation as a whole, but does not have power over everything. The final article is called the judicial branch. This is where the judges decide the fate of the person or law during a trial. The Constitution was written so that if a case is important, it goes through a series of sections before it reaches the Supreme Court. Today, however, the Supreme Court has begun to look for cases. Checks and balances are a safeguard forged to our government to ensure that the three branches, the executive, judicial, and legislative branches, have power over each other in certain cases, and make sure neither branch abuses its power. Overall, this system of checks and balances is made so that every branch monitors the other to ensure that everything is fair and equal within the government. For example, let's pretend legislative branch wanted to pass a law saying that you can only drink Gatorade in public. The judicial branch has the option of reviewing said law and may flag it by saying that the law is unconstitutional, which gives power to the executive branch to veto the law.
Individual rights are protected by the Constitution and the Bill of Rights, which is the first 10 amendments of the Constitution. Written by James Madison in response to several states that wanted more protection for their individual rights, the Bill of Rights lists specific limitations on the government's power. Basically, the Bill of Rights is a list of limits on government power. Amendment 1. Congress shall make no law respecting an establishment of a religion, or prohibiting the free exercise thereof, or abridging the freedom of speech, or of the press, or the right of the people to peaceably to assemble, and to petition the government for a redress of grievances. What the First Amendment means is that the government cannot make a law that gives a certain religion more constitutional protection over other religion, or stops a reasonable practice of them. For example, the government cannot allow public school funding for a Christian school, but not a Jewish one. Also, if a particular religion practices human or animal sacrifice, it would be illegal since it's violating on the rights of other humans and animals. Basically, if the religion isn't infringing on the rights of others or breaks any established laws, the government cannot make a law that targets a certain religion or group. But there are limits on these rights in the First Amendment. This amendment also protects the right of people to peaceably assemble and political freedom of speech. Not all speech is protected under this amendment. Such actions as yelling bomb on a plane or shark at the beach and inducing fear, panic, and provoking violence are not protected.
Some other amendments included in the Bill of Rights are a Second Amendment that says, a well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. The Second Amendment is saying, the government needs a military and this amendment protects it. It also allows the citizens of the country to bear arms within reason. The Fourth Amendment says that the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrant shall issue, but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. This is saying that property cannot be seized without reasonable cause or suspicion. Amendment V. The Fifth Amendment says that no person shall be held to answer for a capital or otherwise infamous crime unless on an indictment of a grand jury, except in cases arising in the land, naval forces, or in the militia, when in service in time of war or public danger, nor shall any person be subject for the same offense to be twice put in jeopardy of life or limb, nor shall be compelled in any criminal case to be a witness against himself, nor be deprived of life, liberty, or property without due process of law, nor shall private property be taken for public use without just compensation. Basically, it is saying that citizens of the United States have a right to a trial with a jury. However, soldiers and other members of the military do not have right necessarily to a jury. Amendment V also protects double jeopardy, which means you can't be tried for the same crime under the same charges twice.
The Sixth Amendment says that in all criminal prosecutions, the accused will have the right of a public trial by an impartial jury of the state and district where the crime had been committed. Another right is to be informed of that cause of the accusation, but to be confronted with the witnesses against him. He will also go through the process for obtaining witnesses in his favor and to have the assistance of counsel for his defense. The Sixth Amendment is basically saying that citizens have the right to a speedy trial. Of course, many people nowadays do not find the judicial process speedy at all, but basically this protects against people being held without knowing what they are being charged for an excessive amount of time. The Constitution, written in 1787, is still in effect today because it allows the government to deal with matters the framers never even thought of, like regulating trade through the internet. The Constitution contains provisions for changing or adding to the document. These plans are called the amendment process. To amend the Constitution is difficult. More than 9,000 changes have been proposed, but only 27 have been passed. Some well-known amendments are the 13th Amendment, which outlaws slavery, the 18th Amendment, which prohibited the production and sale of alcohol, the 19th Amendment, which gave women the right to vote, the 21st Amendment, which overturned Amendment 18 because it was too difficult to enforce, and the 26th Amendment, which guarantees citizens the right to vote at age 18. Although the Constitution can be changed, the 6 goals, 7 major principles, and the Bill of Rights that first appeared in the document must remain the same.